Good day, ma'am. I am here to state the Presidential Decree number 968, Section 1 to 10. Presidential Decree number 968, establishing a provision system, appropriating funds thereof, and for other purposes. Section 1. Title and scope of this decree. This decree shall be known as Probation Law of 1976, shall apply to all offenders except those entitled to the benefits under the provision of Presidential Decree number 603 and similar laws. Section 2. Purpose. This decree shall be interpreted so as to promote the correction and rehabilitation of an offender by providing him with individualized treatment, provide an opportunity for reformation of a penitent offender which might be less probable if he were to serve a prison sentence, and prevent the commission of the crime. Section 3. Meaning of terms such as probation. Probation is a disposition under which a defendant, after conviction and sentence, is released subject to the condition imposed by the court and to the supervision of probation officer. Section probationer means a person placed on probation. Probation officer means one who investigates for the court a referral for probation or supervises probationer or both. Section 4. Grant of probation. Subject to the provision of this decree, the court may, after it shall have convicted and sentenced the defendant, and upon application at any time of the said defendant, suspended the said execution of sentence and placed the defendant on probation for such period and upon such terms and conditions as it may deem best. Section 5. Post-sentence investigation. No person shall be placed on probation except upon prior investigation by the probation officer and a determination by the court that the ends of justice and the best interests of the public, as well as that of the defendant, will be served thereby. Section 6. Form of investigation report. The investigation report to be submitted by probation officer under Section 5 hereof shall be in the form prescribed by the probation administrator and approved by Secretary of Justice. Section 7. Period for submission of investigation report. The probation officer shall submit to the court the investigation report on a defendant not later than 60 days upon receipt of the said order of the court to conduct investigation. The court shall resolve the petition for probation not later than 5 days after receipt of the said report. Section 8. Criteria for placing an offender on probation. In determining whether an offender may be placed on probation, the court shall consider all information relative to the character, antecedent, environment, mental and physical condition of the offender, and the available institutional and community resources. The probation shall be denied if the court finds that the offender is in need for correctional treatment that can be provided most effectively by his commitment to an institution. There is undue risk that during the period of probation, the offender will commit another crime. The seriousness Probation will depreciate the seriousness of the offense committed. Section 9. Section 9. Disqualified offenders. This decree shall not be extended to those sentenced to serve a maximum term of imprisonment of more than 6 years, convicted of any offense against the security of the state, who have previously been convicted of any offense punished by imprisonment of not less than 1 month, 1 day, or a fine of not less than 200 or baht, who have been once on probation under the provision of this decree, who are already serving sentence at the time the substantive provision of this decree become applicable pursuant to Section 33 hereof. Section 10. Condition of probation. Every probation order issued by the court shall contain condition requiring that the probationer present himself to the probation officer designated to undertake his supervision at such place as may be specified in the order within 72 hours after from receipt of the order. Report to the probation officer at least once a month at such time and place as may be specified by said officer.